Go ahead, Madam Chair.
Did you say I can start from top?
Yes, go ahead, please, Madam
Oh,
Chair.
great. Thank you. Good morning, everyone. The meeting of the Commission on State Mandates will come to order at 10:07 a.m. And welcome. Thank you for being here today. Statutes of 2022, Chapter 48 amended the Bagley-Keene Open Meeting Act, and through July 1st, 2023, we have the authority to hold public meetings through teleconferencing. The commission, of course, continues its commitment to ensure that its public meetings are accessible to the public and that the public has the opportunity to observe the meeting and to participate by providing written and verbal comments on commission matters. And the materials today, including the notice, agenda, and witness list, are all available on our website, www.csm-commission-on-state-mandates.ca.gov. And please go there under the hearings tab. And in the event we experience any technical difficulties or we're bumped offline for any reason, we will restart and allow people to rejoin. So with that, Ms. Palchik, if we could please take the roll to establish a quorum.
You mean me, Ms. Halsey?
Oh, I'm sorry, Ms. Halsey.
That's okay. Okay, sure. Member Olson, let staff know that she is not able to attend today's hearing. Mr. Adams?
Here.
Ms. Miller?
Here.
Mr. Morgan?
Here.
Ms. Nash?
Here.
Ms. Paquin?
Here.
Mr. Walker?
Here.
Great, we have a quorum. And our next item is item 1. Are there any objections or corrections to the minutes of January 27th, 2023?
Madam Chair, I would move approval as presented.
Great, thank you, Mr. Adams. We
I'll
have a
second.
Thank you, Mr. Walker. It's been moved and seconded. Any public comment on the minutes? I don't see any. May we take the roll, please, Ms. Halsey, on the minutes?
Sure. Mr. Adams?
Aye.
Ms. Miller?
Aye.
Mr. Morgan?
Aye.
Ms. Nash?
Aye.
Ms. Paquin?
Aye.
Mr. Walker?
Aye.
Great, the minutes are approved.
Now we will take up public comment for matters not on the agenda. Please note that the commission may not take action on items not on the agenda. However, it may schedule issues raised by the public for consideration at future meetings. We invite the public to comment on matters that are on the agenda as they are taken up.
Thank you. Any public comment? Anyone wishing to comment on anything not on the agenda? Ms. Palchik, do you see anyone raising their hand? Just as a reminder, if you'd like to make a public comment, please use the raise hand feature.
I see none, Madam Chair.
Great, thank you very much. We will then move on to swearing in, please.
Will the parties and witnesses for items 3, 4, and 5, please turn on your video and unmute your microphones, and please rise and state your names for the record. Do you solemnly swear or affirm? Oh, sorry. Please state your names for the record. I was going too fast.
Brian Brown.
Fernando Lemos.
Oh, sorry.
David Burhan, item 3.
Amanda Carr, item 3.
Brian Brown, item 3.
Catherine Hagan, item 3.
Jennifer Fordyce, item 3.
And Michael Lawfer, item 3.
Donna Furby, item 3, 4, and 5.
Mr. Lemus, I see
yeah.
you're there, but I didn't hear you.
Okay, I'm sorry. Fernando Lemos, item 4.
Do you solemnly swear or affirm that the testimony which you're about to give is true and correct based on your personal knowledge, information, or belief?
I do.
I do.
I do.
Thank you. Please be seated. Item 2 is reserved for appeals of executive director decisions, and there are no appeals to consider for this hearing. Next is item 3. Chief Legal Counsel Camille Shelton will please turn on her video and unmute her microphone and present a proposed decision on a test claim on order R8 2009-0030 adopted by the Santa Ana Regional Water Quality Control Board. At this time, we invite the parties and witnesses for item 3 to please turn on their video and unmute their microphones.
Good morning, everybody.
Good morning, Ms. Shelton.
This test claim alleges reimbursable costs mandated by the state to comply with a 2009 test claim permit issued by Santa Ana Regional Water Quality Control Board, which identifies waste load allocations for several pollutants in receiving waters to comply with total maximum daily loads, or TMDLs, and requires the claimants to monitor and implement best management practices to ensure compliance with those water quality standards, requires that low impact development and hydromodification prevention be considered in the planning and site design of new development and significant redevelopment projects, including municipal projects, addresses public education and outreach requirements, including to residential areas, and increases the scope of commercial and industrial inspections. Staff finds that many activities alleged in the test claim are not new, but were required by prior law. Staff further finds that the requirement to use low impact development and hydromodification planning principles for new or redeveloped municipal projects is not mandated by the state and is not unique to government, and therefore does not mandate a new program or higher level of service. In addition, consistent with 2 recent Court of Appeal decisions, staff finds that the claimants have the authority to impose regulatory fees for all new mandated activities relating to inspections of commercial and industrial facilities and for the lid and hydromodification prevention planning requirements, which are sufficient as a matter of law to cover the costs, and therefore there are no costs mandated by the state for these activities. Staff does recommend that the commission partially approve the test claim for the new mandated requirements to submit a proposed cooperative watershed program that will fulfill the requirements of the Selenium TMDL, develop a constituent-specific source control plan for copper, lead, and zinc, including a monitoring program, to ensure compliance with waste load allocations for the San Gabriel River Metals TMDL, comply with 3 new activities mandated to implement the public education program, and develop a pilot program to control pollutant discharges from common interest areas and areas managed by homeowner associations or management companies. Although the claimants can impose or increase property-related fees for these new mandated requirements, that authority is limited by Proposition 218, which until January 1st, 2018, requires voter approval before any fees can be improved or can be imposed. In accordance with the recent decision of the 3rd District Court of Appeal, when voter approval of the fees is required, the claimants do not have the authority to levy fees sufficient as a matter of law to cover the costs of these activities. Therefore, staff finds that there are costs mandated by the state for these activities from June 1st, 2009 through December 31st, 2017. Beginning January 1st, 2018, however, there are no costs mandated by the state since Senate Bill 231 amended the government code to make stormwater fees exempt from the voter approval requirement of Proposition 218. Staff recommends that the commission adopt the proposed decision to partially approve the test claim and authorize staff to make any technical or non-substantive change to the decision following the hearing.
Thank you very much, Ms. Shelton. I really appreciate it. I am now, if the parties and witnesses could please state the names for the record. We will begin with Mr. Burnham and Ms. Carr for the claimants, if you'd like to begin. And if you
Yes,
could-
please. This is Dave Burhan, Burhan and Guest Law Firm for claimants in item 3.
And I'm Amanda Carr.
Madam Chair, you're muted.
Oh, excuse me, I apologize. Thank you very much. If you would like to begin, please, and then we'll go to our other witnesses today.
Thank you, Chair Miller and Commission members. As I said, my name is Dave Burhan of the law firm of Burhan and Guest. I'm here today representing the test claimants in this test claim. We appreciate the opportunity to make our arguments today via Zoom. It's a nice opportunity for me to finally see some of the folks at the commission that I've been talking to by phone for years. I want to start with an apology, and the apology is that this will be a presentation full of acronyms. Because if you're in environmental law, you deal and live with acronyms. So I'm just going to talk about 3 at the start, and then we can confuse you later on with some more. The first is MS4, Municipal Separate Storm Sewer System Permits. That's what we're talking about. Those are the public utilities that issue in this permit. And basically think of it as everything from the street gutter and catch basin outside your house to big pipes or channels which discharge into waters like Newport Bay. The second is BMP, Best Management Practices. What are those? They could be a large physical structure that cleans stormwater, or they could be a public education program. But you'll hear a lot of discussion of BMPs. The final one is TMDL, Total Maximum Daily Loads. We'll explain that a little bit more in the presentation, but again, that's what we're talking about. And for the court reporter, can you hear me? I will try to slow down. I can be a little bit of a fast talker. I want to thank first Commission staff for agreeing in the proposed decision that claimants have in fact used proceeds of taxes to pay for the requirements of this executive order. I think the evidence of that is irrefutable, based not only on declarations, but also evidence collected in the ordinary course of business. I also want to note that the cost of these permits is a challenge for local government who have other obligations to meet. That is why we've turned to the commission, pursuant to our constitutional rights, to seek a reimbursement of funds. The record in this case is more than 7,000 pages long. I'm sure something that staff is probably not happy with to manage them on a paper. There's lots of comments and evidence in that record that come from claimants. We're not here today to dredge through all that evidence or to reintroduce all those comments. I am here focusing on certain aspects of the proposed decision. However, I do want to incorporate all of our prior comments and evidence into my presentation today by reference, so that it's clear that there is no waiver of any of that. I'd like to start by discussing section 18, that's XVIII of the test claim permit, which incorporates those TMDLs. And we're talking about section 18, B4, B7, B8, B9, C1, and D1. The proposed decision denies reimbursement for all but 2 of those provisions on the ground that they're not new, that they were simply a continuation of requirements in the previous 2002 stormwater permit adopted by the Santa Ana Water Board. What were those requirements? There are 7 of them. We're going to call them the 7 requirements. 1, that discharges from the MS4 not cause or contribute to exceedances of receiving water quality standards. 2, that illegal and illicit non-stormwater discharges are prohibited from entering the MS4. 3, that drainage area management plans, or DAMPs, had to be designed to achieve compliance with receiving water limitations through timely implementation of control measures and BMPs. 4, that if permittees continue to cause or contribute to an exceedance of water quality standards, they needed to notify and report that to the water board and implement additional BMPs. 5, that permittees were required to demonstrate compliance with discharge limitations and receiving water limitations through timely implementation of those DAMPs. 6, permittees were required to implement additional controls if necessary to reduce the discharge of pollutants in stormwater to the maximum extent practicable, or MEP. And finally, that required permittees to comply with the 2002 permits monitoring and reporting program. Now, these provisions, in our view, do not support the argument that the 2009, the test claim permit, is in fact not new. And we're making that argument not just based on the previous evidence and arguments we've made, but also a very recent case. Department of Finance, the Commission on State Mandates, which I believe was referred to by Ms. Shelton, which specifically holds that general requirements do not indicate the lack of a new requirement in a new permit that has a higher level standard of service. What is this case about? This case actually involved the 2007 county stormwater permit for San Diego County. The state argued that because prior permits had some of the same requirements as the 7 points we just made, that the requirements in that later permit were not new. The state argued that just because a permit condition appeared in a prior permit or had been updated to require additional expenditures, that didn't mean it was new, because the new condition was simply enforcing the same underlying pollution abatement obligations found in the previous permit. Court of Appeal didn't agree. It held that the application of Article 13B, Section 6, quote, does not turn on whether the underlying obligations to abate pollution remain the same. It applies if any executive order, ellipsis, required permittees to provide a new program or higher level of service. How do you determine when a permit condition is new? The court answered this question simply. We compare the legal requirements imposed by the new permit with those in effect before the new permit became effective. This is so, even though the conditions were designed to satisfy the same standard of performance. That holding applies here. First, using the court's test, a simple comparison of the provisions in the test claim permit and the 2002 permit reveals that the test claim permit imposes significantly greater legal requirements due to the incorporation of new TMDLs and implementation requirements associated with them. On that ground alone, Section 18's requirements in the test claim permit are new. I want to just note that the water boards, in fact, agreed with that newness point in their response to the original test claim, March 9th, 2011, on page 26, where they state, claimants correctly note that many of the TMDL derived provisions in Section 18B contain new requirements not found in the 2002 permits. But there's another reason why these provisions are new, and that relates to how TMDLs function and the additional requirements that are placed on the permittees. TMDLs are required for water bodies that are not meeting water quality standards. So to get those water bodies into compliance, TMDLs must be established. In a TMDL, different sources that discharge into the affected water body are given numeric load allocations or waste load allocations, which happens to apply to MS4 permittees, that set forth limits on the amount of pollutants that a party's discharges can contain, measured at the point where the discharge enters the water body. TMDLs and waste load allocations associated with them don't automatically become enforceable once they're adopted. The record shows that many of the TMDLs in the 2009 test claim permit were adopted prior to that permit. However, those do not become enforceable until they are adopted into a federal discharge permit, such as the test claim permit. So that again is an important point as it relates to the 7 points that we just noted from the old permit. Incorporating the test claim permit, TMDLs incorporated into the test claim permit, therefore created a significant difference between this permit and the 2002 permit. It means that permittees now are legally responsible for meeting those specific waste load allocations in their own discharges, something that was not required under the previous permit, and they're required to do so under a timeline. For example, the requirement to meet receiving water limitations in the 2002 permit one, by the way, which is also the test claim permit, did not mean that permittees were also legally required to achieve a specific TMDL wasteload allocation, because those were only applicable in the 2009 permit. With regard to the remainder of the 7 factors that we just discussed that are cited in the proposed decision, the San Diego permit case rejected 2 of them as showing that there was not a new requirement. That is preventing non-stormwater discharges into the MS4 and the need to meet the maximum extent practicable standard. What the court there said is those are perhaps underlying pollutant abatement standards, but they do not themselves mean that new requirements in a subsequent executive order, a test or permit, are new, or they're not new. The damp requirements, which are a large part of those 7 set factors, were aimed at achieving receiving water limitations in some cases, but they were not directed at achieving the TMDL wastelet allocations. Again, TMDLs are not self-executing. So the TMDLs in this test claim would not have been a performance goal for those dams since they weren't in the permit. Also, dams are only required to meet the MEP performance standard, which is less stringent than having to meet numeric objectives, such as a TMDL wastelet allocation. Our November comments discuss that difference quite extensively. Thus, there were no requirements in the dams that had to meet TMDL requirements unless those TMDL wastelet allocations were incorporated into the prior permit. And again, they were not. And finally, the monitoring program, also cited by the proposed decision, certainly established a fairly extensive monitoring program, but the TMDL monitoring, and we're going to talk about some of that today, was a higher level of service, a more extensive monitoring program that was triggered by the incorporation of the TMDLs into the test claim permit. That is a new program or higher level of service. The proposed decision claims that the fecal coliform TMDL for Newport Bay was already incorporated into the 2002 permit and thus was not new. In support, they cite a finding in that permit that the 2002 permit did in fact incorporate the fecal coliform TMDL, but a closer look at that suggests that this is wrong. The TMDL incorporation section of the 2002 permit, which is section 16, sets forth numeric load allocations for nitrogen, phosphorus, and sediment TMDLs, which are not in this test claim. However, section 16 reflects no load allocations for fecal coliform, only the requirement that permittees had to revise their dams to include implementation measures and schedules for further studies related to this TMDL. The first permit to incorporate the specific numeric wastelet allocations for the fecal coliform TMDL was a test claim permit in section 18C1, which is at issue today. Turning to a different issue, the proposed decision finds that the preparation of a cooperative watershed program, we'll call that the CWP, to address selenium TMDL in section 18B8 of the test claim permit and preparation of a constituent specific source control plan or CSSP for the San Gabriel River and Coyote Creek Meadows TMDL are reimbursable state mandates. And this is obvious, but I want to note another point. The test claim permit requires not only preparation, but implementation of the CWP and the CSSP. And section 18B8, for example, states that the program must be implemented upon regional board approval. Section 18B9 requires the permittees to develop and implement the CSSP. However, while reimbursement of the CWP and CSSP preparation costs are allowed in the proposed decision, implementation costs are not. The proposed decision does not explain its rationale beyond citing those 7 factors. But those factors are cited to show that the requirements were supposedly not new in the test claim permit. But if preparation of the CWP and the CSSP is a new mandate in the test claim permit, as the proposed decision agrees, then the implementation of programs set forth in those documents must also be a new program or higher level of service. I would now like to call Amanda Carr, who is Deputy Director of OC Environmental Resources, to briefly discuss what implementation activities were undertaken under the CSSP and the CWP.
Great,
At
Ms.
this-
you can state your name for the record. I do just want to, Mr. Bernheim, I just want to say that our staff, part of what we do is go through pages and pages of documents. So that is our job, and we do it with great integrity and pride. So there's never too much information, but I do want to make sure that when we're presenting these ideas that we are succinct and do it without repeating anything a previous presenter has repeated.
Thank you, Chair. Chairman, I will attempt to abridge the remainder of my comments.
Thank you.
If I could ask, maybe Ms. McGee, we'd like to share a document on the screen.
Yes, thank you, Mr. Burhan. Our IT team will share. Are you referring to the Coyote Creek?
Yes, ma'am, that is it.
Thank you, and thank you for giving us letting us know that you wanted to share this on the screen. We appreciate it.
Certainly, thank you. Good morning, Ms. Carr. Could I just ask you to provide the commission members with a description of the role you play?
Yes, good morning. My name is Amanda Carr. I'm Deputy Director for OC Environmental Resources in Orange County Public Works. And in that role, I oversee the Orange County Stormwater Program for the county, the Orange County Flood Control District, and the 34 cities within Orange County.
Thank you. I also now direct your attention to the document that's been shared on the screen. Do you recognize that document?
Yes, this is the CSSP that was developed by the consulting firm Camp Dresser and McKee. It's a series of 4 technical memorandums that cover a review of metals data within the Coyote Creek and San Gabriel River watersheds. It also then developed a monitoring program specifically for the Coyote Creek area within Orange County. And it reviewed the data for a third technical memorandum reviewed the data from sub watersheds within the Coyote Creek watershed, identifying potential sources and best management practices to address those sources of metals within the watershed. And then lastly, it developed a monitoring report outline for the reporting of the data from the monitoring plan.
Thank you. At this time, would it be in order to request that this document be added to the record?
It has already been added and served.
Thank you so much, Ms. Halsey. Let's proceed then.
Thank you. Would you like us to continue sharing this screen?
No, ma'am. Let's just go back. I think better just there. Thank you very much.
Thank you.
Ms. Carr, of the 4 elements of the CSSP that you described, did any require subsequent implementation?
Yes, the monitoring program required subsequent implementation. In this program, 6 monitoring locations were required. 1 in Cypress, 3 in Buena Park, 1 in La Habra, and 1 in Fullerton. And these stations were, it was determined that monthly monitoring was necessary at these locations for physical parameters such as hardness and temperature, pH, basically the physical quality of the water in the creek, as well as for the metals covered in the TMDL, including silver, cadmium, chromium, copper, nickel, lead, zinc, calcium, and magnesium.
Was this monitoring done by the permittees as part of the core monitoring program required by the 2002 permit?
No, this was an additional work. Basically, this was actually approximately a 5-fold increase in the monitoring that was done in this area under the permit, specifically for the TMDL. Under the permit, what had previously been required was monitoring at 3 locations and semi-annually, so at those locations twice per year and during 3 storm events. Under the TMDL program, that frequency was now increased to monthly monitoring, as well as the locations were increased from 3 locations to 6.
Thank you. And who paid for the cost of this monitoring?
The monitoring was collectively paid for by the county, the flood control district, and the cities in the Coyote Creek watershed.
Thank you. Are you familiar with the cooperative watershed program regarding compliance with the selenium TMDL in the Newport Bay watershed?
Yes, the CWP was designated as the compliance mechanism for the selenium TMDL within the test claim permit. And it required the development of strategies to address selenium within the Newport Bay watershed.
Are there particular problems that are faced by permittees in addressing selenium?
Yes, actually, selenium is an extremely challenging pollutant. This is a naturally occurring element that's sequestered in the soils within the watershed. So rather than typical stormwater pollutants that are generated through urban or industrial activities and that are washed off the land surface into the storm drain system, selenium enters the storm drain system through rising groundwater that leaks into storm drain pipes. So it's not a controllable pollutant or volume of water. It responds to changes in groundwater in the watershed, and then it leaks into the pipe, which then discharges into the creek. So this requires a whole new level of research and BMP development, different than any other stormwater pollutant.
Thank you. Did the permittees subject to this TMDL engage in the CWP?
Yes, they did. The CWP resulted in what we call the BMP strategic plan, or best management practice strategic plan. The development of this plan overlapped with our response to a time schedule order for selenium that was issued shortly after the test claim permit. So the BMP strategic plan for selenium references both the test claim permit and the time schedule order requirements.
Thank you. And could you briefly describe what tasks were to be implemented in the CWP?
Yeah, the CWP broke down our activities into 3 categories: early action requirements, phase 1 and phase 2. And each of these 3 phases depended on evaluation of the previous phases to develop the next steps. So the early action phase really summarized activities that had been completed by the time the plan was eventually submitted. And the subsequent phases, phase 1 and phase 2, were the activities that were undertaken under the CWP.
Great. And again, briefly, because I know time is going, could you just lay out what phase 1 tasks were completed under the CWP?
Certainly. Under the CWP the phase 1 tasks, that 4 of which there were 5 tasks identified in phase 1, 4 of which were completed. Task 2 was a pollution prevention and source control plan best management practices, which focused on really attempting to control groundwater levels within the watershed, as well as preventing groundwater from getting into the pipes. So these resulted in special pipe fittings to prevent groundwater, limiting landscape water application, and also developing natural wetland system technologies to attempt to sequester selenium once it was mobilized in groundwater. Task 3 was development of strategies for a particular sub-watershed within the Newport Bay called the Big Canyon Wash sub-watershed. Those activities were subsequently implemented by the city of Newport Beach, as that watershed is solely within that city. Task 4 was an evaluation of groundwater pump and treat technologies. And that was ultimately determined not to be practical as frankly, the technology didn't work in reducing selenium to the levels that were required by the permit. And lastly, Task 5 was an evaluation of diverting the discharges to the sanitary sewer. And that was completed and led to the development of the projects that were implemented in Task 2.
Could you briefly describe those broad?
Sorry,
Could you-
phase 2, yeah.
I'm sorry. Could you just briefly name and describe briefly again the projects that were undertaken in phase 2 out of the CWP?
Yeah, so in phase 2, we evaluated locations of where the discharges could be diverted to the collected and discharged into the sanitary system. That resulted in 2 projects. One was the Peters Canyon Wash Water Capture and Reuse Pipeline Project. And the second was the Santa Ana Delhi Diversion Project. Both of these projects were designed to divert high selenium dry weather flows into the Orange County Sanitation District system, where it was treated and then discharged to the groundwater replenishment system managed by Orange County Water District for beneficial reuse.
Thank you. One last question. Were the projects that you have just described begun after the date of the BMP strategic plan, which I believe was January 1st, 2011?
Yes, they were.
Thank you very much. No further questions. I'd like to now finish our presentation. I will try to speed it up. I certainly understand the chair's admonition. I think that the evidence suggested use from Ms. Carr shows that there were substantial implementation programs required by the CSSP and the CWP that were undertaken and which we believe qualify for reimbursement of and subvention of funds. There was another comment in the proposed decision I want to briefly address, namely that the wastewater allocation for San Gabriel River metals TMDL were not unique to government because other private discharges had similar allocations. That's not the law. This relates to what is a program under Article 13B, Section 6. And court cases have made very clear that if you are either providing a service to the public through your activities, which clearly the MS4 permittees are, or the requirements of the test claim permit are unique to local government, then that meets the requirement of Section 6 program. We discussed this in our November 6th comments, and I think they speak for themselves. In addition, I want to talk briefly about Section 12 of the test claim permit, which relates to priority development projects. We had argued that at least 3 projects, 2 county administration buildings and a transitional home for the homeless, were in fact practically compelled because they were the only reasonable means to carry out core mandatory functions, or that the failure of us to do that would subject the government to certain severe penalties. With respect to the transitional housing, we made the point that cities and counties no longer have the ability to ignore the homeless problem and should not, and thus were required, really under penalty of potential litigation, to do projects such as the transitional housing project. Similarly, with respect to the administration building, that was the only reasonable way to have county government in a place where people, different departments could interact and the public could be there to see the activities of government. I also would note that because of the nature of these structures and the services they must provide, there was no choice for the county but to build them at a size that qualified for them as PDPs, and thus subject to the LID and hydro modification mandates in the permit. Finally, I want to briefly discuss SB 231. Senate Bill 231 proposed to change the definition of sewer services, which is exempt from the voter approval requirements in Article 13D, to include stormwater sewers. We believe that that is unconstitutional. We understand that the proposed decision is accepting it. I understand it still is technically good law, but the San Diego permit appeal case that we mentioned earlier made it very clear that SB 231 does not reflect the views of the voters when they adopted Prop 218. And we think that ultimately it's very important that SB 231 be declared unconstitutional because it should not be used to deny reimbursement. I began by talking about the cost of permit compliance. As one person remarked about these permits, the costs that local jurisdictions, including cities, counties, and other public entities incur to comply with these requirements can be significant. That person wasn't a mayor or a council member or a county supervisor. It was a state auditor herself. In the absence of adequate state funding for these increasingly complex stormwater permits which local governments implement each and every day, these municipalities must continue to come to the commission to seek assistance pursuant to the California Constitution. I want to thank you very much for this opportunity to speak on this important test claim, which is the first, I think, of many that will be heard by the commission. And I would, if required, I would like to reserve a few minutes for a response. Thank you very much.
Great, thank you very much for that thorough presentation. We appreciate it, and thank you for being here. I do, just for level set, that this commission does not opine on the constitutionality of bills and laws. So that is not something that we're able to discuss today because that's not within our jurisdiction. I think next we'll move please to the Department of Finance. If you can unmute yourself and turn your camera on, please, Ms. Farabee.
Hello, thank you. Hi, good morning. Donna Furby, Department of Finance. While the Department of Finance does not agree that this test claim permit imposes a reimbursable state mandate, we do acknowledge the decisions of the California Supreme Court and Court of Appeal. We would like to say that we agree with the staff analysis finding that claimants have fee authority after December 31st, 2017 under SB 231. And Finance would like to defer now to the State Water Resources Control Board and Santa Ana Regional Water Quality Control Board for further comment. And we join in their comments and testimony today. Thank you.
Thank you very much, Ms. Farabee. Ms. Portis, Ms. Hagan, and Mr. Loffer for the State Water Resources Control Board and Santa Ana Regional Water Quality Control Board. Will you please unmute yourselves? Turn your cameras on. And please, oh, there you are. Thank you very much. And if you could please state your names before you begin speaking for our court reporter.
Sure. Can you hear me okay?
I can. May I make sure that the court reporter can hear okay, please?
It's a little fuzzy, but why don't you get going and I'll let you know if I cannot hear you.
Okay, great. If you could speak up a little bit, I think we're having a little audio issue. So just speak up as loudly as you can, please.
Yes, my name is, good morning, commission members and staff. My name is Catherine Hagan, and I'm speaking today on behalf of the State Water Board and the Santa Ana Water Board. Also with me today are Michael Loffer, the State Water Board's Chief Counsel, and Assistant Chief Counsel Jennifer Fordyce. I first want to acknowledge the commission and the commission staff's exhaustive and thorough work on this proposed decision. The issues requiring analysis in this matter are extensive and complicated and have been affected and informed by years of litigation along the way. While the water boards don't always agree with all points with the commission, we do greatly appreciate all of the very hard work that has gone into developing the proposed decision that you're considering today. We plan to make only brief comments today, but do want to reiterate that we affirm our written comments in this matter submitted previously and note that we do not waive any issues raised in those written comments by limiting our comments here today to a handful of points. The water boards agree with a number of the conclusions in the commission's proposed decision, and I'll highlight a few of these here. First, the water boards appreciate the detailed discussion of the permit's requirements in section 18 of the permit that claimants comply with waste load allocations for multiple pollutants subject to total maximum daily loads, and that they conduct monitoring for these pollutants and implement best management practices to achieve compliance. The water boards agree with the commission's conclusion that, or the staff's conclusion, that for the most part, these challenge requirements are not new programs. claimants were required in the prior permit issued by the Santa Ana Water Board to comply with water quality standards for these same pollutants, and were also required to monitor, implement BMP's best management practices and reevaluate them if the monitoring showed continued exceedances of the pollutant standards. The commission's detailed analysis correctly notes that the permittees were already required to comply with water quality standards in their prior permit, and that inclusion of waste load allocation requirements to protect these same standards does not result in the imposition of a new program or higher level of service. Also, it's important to note that the Santa Ana Water Board's inclusion of waste load allocations identified in total maximum daily loads effectively provides claimants with more time, or a compliance plan, if you will, to meet water quality standards that have been in place in prior permits, but not yet achieved by the claimants. The permit provisions at issue here are qualitatively different than those considered in the recent 3rd District Court of Appeal decision considering the 2007 San Diego County MS4 permit test claim, where the commission found permit conditions designed to meet a performance standard were a new program. The 3rd District Court of Appeal was not evaluating the specific permit requirements. Instead, it was simply dealing with the standard as set forth in the Clean Water Act's statutory text. It was not analyzing the specific permit requirements. And here in the Santa Ana case, there was an expressed prior permit requirement to comply with water quality standards. As a result, Alameda County's contention and Mr. Burhan's contention in his oral comments today that the commission's analysis here is contrary to the 3rd District Court of Appeals recent decision is incorrect in our view. The 3rd District Court of Appeal decision was not evaluating the specific permit requirements and is inapplicable to the circumstances here where the permittees have already been required to comply with water quality standards and have been given a schedule to do so. The draft decision prepared by the commission staff carefully considered the issue of whether the programs are new and considered the specific requirements in the prior permit as part of its analysis. In doing so, staff in the proposed decision find them to be consistent with the 3rd District Court of Appeal decision, which is not applicable in this context, given the prior specific permit requirements. Second, the water boards agree as well with the commission staff's reasoning to deny the test claim as to the low impact development and hydromodification management requirements for new development and significant redevelopment municipal projects voluntarily carried out by local agencies such as claimants. The test claim permit does not compel local agencies to undertake development or redevelopment projects. And we agree with the commission's analysis on this point. Finally, with regard to fee authority as a general matter, the water boards fully support the commission staff's conclusion that in instances where the commission finds that a test claim permit imposes a state mandate, claimants have the authority to implement permit provisions and are not entitled to reimbursement for costs incurred from January 1st, 2018 forward. The water board's main point of disagreement that we want to bring to the commission's attention concerns the proposed decision's conclusion that the provision regarding development of a cooperative watershed program to address selenium imposes a state mandate. As stated in our written comments, the provision allowing development of this cooperative watershed program was included at claimants' urging and was designed to provide claimants the option to continue stakeholder-initiated work to address selenium rather than directly complying with waste load allocations to implement the selenium total maximum daily load. The permit was intended to provide permittees with a choice to develop this program. For these reasons, the water boards do not agree that the permit taken as a whole mandates the development of the cooperative watershed program, and the test claim on this provision should be denied. Last, we do want to note that after the extremely lengthy process to get from the initial test claim to this proposed decision today, the water boards find it frustrating that it was not until after the draft proposed decision was released in August that claimants submitted substantial amounts of evidence of costs that they claim were incurred to implement the challenge permit provisions. In our view, such evidence is foundational to establishing the elements of a test claim in the first instance and should have been submitted sooner. Submittal at this late point in the process precluded the Water Board's ability to respond in writing to this late evidence for the commission hearing today. In closing, we do want to reiterate our appreciation for the commission's thoughtful and thorough proposed decision in this test claim matter. And for the reasons stated today and in our written comments, we ask that the proposed decision be revised to deny the test claim as to development of the cooperative watershed program, and otherwise to adopt the proposed decision as drafted. That concludes the Water Board's remarks, and we're happy to answer any questions the commission may have.
Great, thank you very much. We're going to wait until after all the witnesses have spoken for questions. For the Santa Ana Regional Water Control Board, did Mr. Loffer, do you have any additional comments?
No, neither Mr. Loffer nor Ms. Fordyce have additional comments at this time.
Great. Thank you very much. We'll now turn it to Mr. Brown. Do you have additional comments on behalf of interested person Alameda Countywide Clean Water Program?
Good morning. My name is Brian Brown. I'm attorney with Myers Nave. We represent City of Dublin and Union City and consolidated test claims 16 TC 03 et al., which are pending. And we also are appearing on behalf of the Alameda Countywide Clean Water Program as an interested member of the public. And we join in Mr. Burhan's comments. We also, I prepared a short presentation about 5 minutes, but there is some overlap, but I think it is also in rebuttal to the State Board's comments. So I will try to present an abbreviated version of that, if we can put that on screen.
Please, thank you. Thank
Okay.
you. And again, we don't want to repeat anything that's already been said. Thank you.
Okay. Well, again, like others, I'd like to thank the commission for the opportunity to comment this hearing, and would like to thank commission staff for the substantial amount of work to put in the proposed decision. So I don't want to repeat. So if we can just skip to slide 2, please. Next one, please. This is, and again, I'm commenting on the Section 18 TMDL requirements. And I thought it's instructive just to see what the state argued in the San Diego decision that the Court of Appeal rejected. And the state there argued that a condition that did not appear in prior permits or has been updated to require additional expenditures is not new because it does not increase permittee's underlying obligation to eliminate or reduce the discharge of pollutants from their MS4s to the maximum extent practicable. Rather, the condition ensures compliance with the same standard that has applied since 1990 when the permittees obtained their first permit. If you can go to the next slide, please. The court rejected this argument, stating the application of Section 6 does not turn on whether the underlying obligation to abate pollution remains the same. To determine whether a program imposed by the permit is new, we compare the legal requirements imposed by the new permit with those in effect before the permit became effective. If you could slide to the next slide, please. Now on page 20, for example, the proposed decision makes the same arguments that were rejected by the state in the San Diego decision, relying on generalized pre-existing Clean Water Act requirements. So just the next slide, please. Now, the proposed decision relies on, for example, prohibited illegal and illicit non-stormwater discharges from entering MS4s. If you can see under the Clean Water Act, section P404 P3 BII, that's the same standard. And in the San Diego case, the state cited Clean Water Act's general requirement to reduce the discharge of pollutants to the maximum extent practicable under 404 P3 BII. You can see those two permit requirements are right next to each other in the Clean Water Act, and their general requirements. So the state and the proposed decision make the same argument rejected in the San Diego case. And to avoid repetition, I'll conclude my comments here, and thank you very much for your time.
Thank you very much. I really appreciate that. So before we turn it to board questions, I'm going to see if there's any other public comments on this matter and really appreciate everyone taking the time this morning. Any public comment? Anyone wishing to comment? Again, you can unmute yourself. You can raise your Zoom hand.
I'm seeing none, Madam Chair.
Great, thank you, Ms. Butler. And for callers, just a reminder that in order to provide public comment, you would push *6. Great. Seeing no public comment, I'll now turn it to the board for questions. No questions from the board? Ms. Shelton, were you gonna?
Madam Chair, yes, I'd be happy to respond to some of the issues today if the commission would like
Yeah,
that.
that was actually going to be my exact question. Thank you, Ms.
Okay.
Shelton. Appreciate it.
Thank you. Mr. Burhan, for the claimants here, made a few points that I did want to respond to. One, he did thank the commission or the commission staff for finding that all the claimants have used their proceeds of taxes. This decision finds specifically that the 5 cities, there was evidence in the record that they spent their proceeds of taxes on this program. We have a declaration from the county and the flood control district that they did, but we also questioned that given the graphs that were included in their report of waste discharge. So with the finding and the evidence that those 5 cities did spend their proceeds of taxes, the commission can approve or partially approve this test claim, but the controller still has the ability to go through and audit their reimbursement claims to determine whether, in fact, proceeds of taxes were used. I do know that the principal permittee, which is the county, I believe, or the county flood control district, did take in money from cities, and they had some grant monies. And then to the extent they use those grant monies or monies from fees or monies from other cities that were not their proceeds of taxes, that is not eligible for reimbursement. So I just wanted to make that point clear. On the TMDL provisions, the parties are talking about the 2002 Department of Finance case, and that case is absolutely distinguishable. One, because the state was making the general argument that all NPDES stormwater permits were never going to be eligible for reimbursement because they did not impose a new program or higher level of service, but were simply used to enforce the same standard. And in that case, those activities were determined to be new. There was no dispute about that. And so the court, as the State Water Board just mentioned, did not do an analysis of the specific mandated activities in this case. Here we are finding there are specific activities that are new and mandated and recommend approval of those, but the requirements to comply with most of the TMDL provisions, which are just to simply implement BMPs and to monitor, are not new requirements. Mr. Burhan suggested that the monitoring is more expensive or extensive, and that might be true, but that would be an increased cost. But it's not a new program or higher level of service. It's not a different activity. The activities required are the same in federal law and the same in the prior permit. There was a lot of discussion about the cooperative watershed program. First, let me just address the Water Board's argument that the plain language of the test claim permit states that the permittees must develop the cooperative watershed program. The courts have determined that under rules of statutory interpretation that the word must is typically mandatory. They suggest that the claimants had requested that requirement be placed in the permit. And Government Code section 17556A does allow for a finding of no cost mandated by the state with a specific request by a party or a claimant. But you need evidence in the record of that from the governing body that they requested that requirement, or evidence of a letter from a delegated representative of the governing body. And we don't have any evidence of their request, so we can't make that finding. On the implementation of the cooperative watershed program, we are recommending that the commission deny that. The implementation of the cooperative watershed program is discretionary. They were given the choice of implementing that or implementing section 4 under that provision. And section 4 simply requires that they monitor and implement BMPs. If they choose to implement a cooperative watershed program, they're not required to comply with a waste load allocation. So certainly they had an incentive to implement the cooperative watershed program, but it's not required that they do so. And all of their activities are not new in that respect. And just to mention on the priority development projects for low impact development and hydro modification, there the claimant was requesting reimbursement specifically for municipal priority development projects. Those requirements are imposed on all priority development projects, which are based on the size of the project and the size of the project and how each of those projects affect the water quality standards. They apply to both public and private projects and are simply not unique to local government. We are therefore, recommending that the commission deny those requirements, even if the commission were to find that they, the transitional housing and the civic center were mandated by the state. Although there's no evidence of that, that they were practically compelled to do so. There's conclusions, but not any evidence from the governing body. And that's all I have, and I'm happy to answer any questions.
Thank you very much. We will turn it to you, Mr. Burhan, at your request. But before that, are there any additional questions for Ms. Shelton from the board? Seeing none, I'm going to limit this rebuttal just to about 5 minutes just to see if there's any additional information before I take it back to the board. So Mr. Burhan, for the claimants, I'd like to start with you or Ms. Carr.
Yes, I'll handle it. Thank you, Chair Miller. Yeah, I'm going to try to go under 5. I've been going over all day. First of all, I also want to add our thanks to commission staff for a very thorough analysis. And even though we don't agree with all of it, it certainly was a major effort. I would like to address a few comments by Ms. Shelton. Yes, when it comes to parameters and guidance, every claimant will have to justify its claim. We understand that. With respect to the CSSP, which was not addressed by any of the other parties, that was a new project. That was a project that was not the existing monitoring, but a new monitoring project. It certainly involved additional costs, which are set forth in the declaration of Mr. Fortuna, but it is in fact a new program. And that was required by section 18B9 of the permit, which required a monitoring program. So I would just like to make that point. Thank you.
Thank you. I appreciate that. Ms. Shelton, do you want to respond to that?
Well, thank you. The issue of whether something is new is a question of law, and it is determined based on the plain language of the permit and what was required by the prior permit in federal law, and the requirement to comply with that constituent specific source control program for metals was it just simply required monitoring and implementing BMPs, and those were the same activities that were required by the prior permit and by federal law. I'm sure you had increased costs, but the courts have made it very clear that increased costs alone are not does not entitle you to reimbursement under Article 13B, Section 6.
Thank you, Ms. Shelton. I do think that is often the question is what is new, and I think there's a lot of mandate law that establishes that costs alone do not constitute a new program. Any other questions from board members? Any other party or witness that wants to have any additional comment before we wrap up? I'll turn it to Mr. Adams, and then if any of the additional parties or witnesses would like to make an additional statement, please turn your camera on and raise your Zoom hand so that we know you would like to make an additional comment. Mr. Adams, please.
Thank you, Madam Chair. I just wanted to mention, I appreciate the thoughtful and extensive work put into this by all involved. I understand there's respect the difference of opinion, but I do support the staff recommendation. Thanks.
Great, thank you. So just one last opportunity. It sounds like Mr. Adams is ready to make a motion. One last opportunity for either public comment or any of the witnesses or parties. Would anyone like to make any final statements?
Yeah, it's Scott Morgan, Alps Planning Research. Yeah, great work by everybody. I do sympathize with the claimants. You know, we continue to pass along fees to local jurisdictions and ultimately to local taxpayers. And I definitely sympathize, but I think it's a matter of law here that I agree with the staff recommendation as well.
Great, thank you, Mr. Morgan. So seeing no additional public comment and seeing no additional comments by the claimants, I'm going to ask actually that you, Mr. Adams, if you'd like to make that official motion for us to adopt the staff recommendations.
Madam Chair, I would.
Great, thank you, Mr. Adams. And may we have a second?
Second.
Great, thank you, Ms. Nash. We have a motion and a second, moved by Mr. Adams, seconded by Ms. Nash. And we are ready, Ms. Halsey, to please take the roll.
Mr. Adams,
Aye.
Mr. Adams, on mute. Thank you.
Ms. Miller,
Hi.
Mr. Morgan,
Aye.
Ms. Nash,
Aye.
Ms. Pequin,
Aye.
Mr. Walker.
Aye.
Great, that motion carries and the staff recommendation is adopted. Again, to our parties and witnesses for the incredible amount of effort and work you put into this. Thank you very much for being here. And of course, to the team at the Commission on State Mandates, we are really grateful. So we'll move on to item 4. I just want to let the committee know that our court
Sorry,
reporter.
I was just, yes, go ahead. You were going to mention the court reporter.
Hi. That our court reporter needs to take a break at 11:30. So I think what we're going to do is try and see how quickly we can move through this next item, and we may just take a quick pause at 11:30, and then at that time, if the court reporter could give us an estimate of how long a recess we should take.
Thanks, Madam Chair.
Thank you very much. So with that, we'll move to item 4, please.
Senior Commission Counsel Juliana Murr will please turn on her video and unmute her microphone and present a proposed decision and parameters and guidelines on juveniles custodial interrogation. At this time, we invite the parties and witnesses for item 4 to please turn on their video and unmute their microphones.
Thank you very much, Ms. Murr. Good morning. Nice to see you.
Good morning. These parameters and guidelines address a change to Welfare Institution Code Section 625.6, requiring cities and counties to ensure that youths ages 16 and 17 consult with legal counsel prior to custodial interrogation and before the waiver of any Miranda rights. On January 27, 2023, the Commission adopted its test claim decision, finding that the test claim statute imposes a reimbursable state mandated program within the meaning of Article 13B, Section 6 of the California Constitution. The proposed parameters and guidelines identify the one activity approved by the Commission and include 2 sources of state funds as potential offsetting revenues. No substantive comments were filed on the expedited parameters and guidelines. Accordingly, staff recommends that the Commission adopt the proposed decision and parameters and guidelines and authorize staff to make any technical, non-substantive changes to the proposed decision following the hearing.
Great, thank you very much. If the parties and witnesses could please. Oh, thank you. You've already done it. Could please state your names for the record. I appreciate it. Mr. Lemus, if you would like to start for the County of Los Angeles, please.
Yes, good morning. My name is Fernando Lemus. I am the claimant representative for the County of Los Angeles. And I'm here to say that we have no further comments. We urge the Commission to adopt the Ps and Gs.
Thank you very much for that. Ms. Farabee, please, for the Department of Finance.
Donna Furby, Department of Finance. The Department of Finance has no objections to the adoption of the proposed decision and parameters and guidelines. Thank you.
Thank you very much. Any questions from the board? Seeing none, thank you, Ms. Murr. Any public comment?
I see none, Madam Chair.
Great, thank you very much. Seeing none, may we have a motion then to adopt the staff recommendation, please? I will move. May we have a second, please?
I would second, Madam Chair.
Thank you very much, Mr. Adams. Moved by Miller, seconded by Adams. Confirming no public comment, no board questions. Ms. Halsey, will you please call the roll?
Mr. Adams,
Sorry, couldn't get to my mute button. Aye.
Thank you.
Ms. Miller,
Aye.
Mr. Morgan,
Aye.
Ms. Nash,
Aye.
Ms. Paquin,
Aye.
Mr.
Great.
Walker.
Aye.
Thank you. That motion carries. We're gonna try and see if in the time we have allotted, we can get to item 5, please, Ms. Halsey.
Sure. Senior Commission Counsel Eric Feller will please turn on his video and unmute his microphone and present a proposed decision and parameters and guidelines amendment on racial and identity profiling. At this time, we invite the parties and witnesses for item 5 to please turn on their video and unmute their microphones. The requester has contacted commission staff and stated that they agree with the staff analysis and clarifying language to the parameters and guidelines and will not appear for this item. The requester thanks the commissioners and the staff for their time on this request.
Thank you very much, Ms. Halsey. Mr. Feller, please.
Good morning. This item originated in a request to amend the racial and racial and identity profiling parameters and guidelines to authorize reimbursement to purchase cellular telephones loaded with Racial and Identity Profiling Act reporting software. Staff finds that the parameters and guidelines already authorize reimbursement for the costs incurred in reimbursable activities.
Mr. Feller, I'm sorry, this is the court reporter. Your audio is cutting in and out. So I'm going to back you up. Staff finds the parameters and guidelines also authorize. Continue, please.
Staff finds that the parameters and guidelines already authorize reimbursement for the costs incurred to comply with the reimbursable activities, including the requested cell phones, so the amendment is not necessary and the request should be denied. However, staff does recommend amending the reimbursable activities section to add clarifying language consistent with the testing regulations that, quote, in-car mobile data computers, laptops, tablets, or smartphones may be used to comply with this activity. Staff also recommends that the commission update section 5B, indirect cost rates, to include updated citations to the federal law on indirect costs. The parties filed comments agreeing with the proposed decision. So staff recommends that the commission adopt the proposed decision and parameters and guidelines amendment and authorize staff to make any technical non-substantive changes to the proposed decision following the hearing.
Great, thank you very much. If Ms. Farabee for the Department of Finance, do you have any comments?
Yes, Donna Furby, Department of Finance. Department of Finance has no objections to the staff recommendation. Thank you.
Thank you very much. Any questions from the board? Any public comment? Anyone wishing to comment for any reason? Seeing none, may we have a motion to adopt the staff recommendation?
So moved.
Thank you, Mr. Walker. Moved by Mr. Walker, seconded by Ms. Nash. Ms. Halsey, will you take the roll, please?
Mr. Adams,
Aye.
Ms. Miller,
Aye.
Mr. Morgan,
Aye.
Ms. Nash,
Aye.
Ms. Paquin,
Aye.
Mr. Walker.
Aye.
Great, that motion carried. The staff recommendation is adopted. We'll now move to item 6, please.
Item 6 is reserved for county applications for a finding of significant financial distress, or SB 1033 applications. No SB 1033 applications have been filed. Next, Program Analyst Jill McGee will please turn on her video and microphone and present item 7, the legislative update.
Good morning. The following are the legislative updates since the last time the commission met. First, AB 1306, State Government. This bill proposes a non-substantive change to Government Code Section 17552, which sets forth the sole procedure by which local agencies and school districts may claim reimbursement for costs mandated by the state. According to the author's office, this is a spot bill. Second, AB 961, State Mandates Claims. This bill proposes to amend Government Code Section 17564 and reduce the statutorily required minimum amount of costs incurred to file a mandate reimbursement claim from $1,000 to $800. According to the author's office, this is a spot bill. Staff will continue to monitor legislation for bills that impact the mandates process. Thank you.
Thank you, Jill. Next, Chief Legal Counsel Camille Shelton will please turn on her video and microphone and present item 8, the Chief Legal Counsel report.
Good morning. We do have one recent decision from the California Supreme Court. They
I'm
denied.
sorry, Camille, this is Heidi. I think we lost Miss Miller. She's just reconnecting. One moment, please.
Miss Halsey, I was kicked off Zoom. Was anyone else? No,
No, sorry about that.
no, I'm so sorry. I will try, I'm joining from my phone. I'll try and rejoin from my computer. Are we able to hear the report from Miss McGee? Is she?
She did present. I thought you had shut off your camera for a minute. I didn't realize you had been bumped out. So we kept
Great.
going.
No worries at all. I appreciate that. Where are we on the agenda then?
Ms. Shelton is about to do her Chief Legal Counsel report.
Great, thank you, Ms. Shelton.
Good morning. We do have a recent decision by the California Supreme Court on the Department of Finance versus Commission on State Mandates case. This was the case that we discussed in item 3. As you recall, the Third District Court of Appeal upheld the commission's decision except for the finding of street sweeping, which is reversed consistent with the court's earlier decision in Paradise Irrigation District. In December, the state filed a petition for review on the fee authority issues, as well as the court's earlier decision finding that the activities are mandated by the state and not by federal law. On March 2nd, the Supreme Court denied review in that case. On our litigation calendar, we have a trial setting conference set for April 13th, 2023 in County of Los Angeles versus Commission on State Mandates. That is the challenge on the commission's decision on municipal stormwater and urban runoff discharge consolidated incorrect reduction claims. And that's all I have today.
Great, thank you very much. I appreciate it. We will now get the executive director's report, and Ms. Halsey, if we can try and do that in 5 minutes so that we can give our court report.
Sure. First, our 2022-2023 budget. On April 18th, 2023, the commission's budget will be heard in Assembly Budget Subcommittee 4. And then for workload, after this hearing, there are 39 pending test claims, 37 of which are regarding stormwater and PDES permits. There's also 1 parameters and guidelines active and pending. On inactive status, pending the outcome of litigation, there is 1 more parameters and guidelines regarding stormwater discharges. Commission staff expect to complete all currently pending test claims by approximately December 5th, 2025, and depending on staff and other workload. However, some of the test claims may be heard and decided earlier than currently indicated if they're consolidated for hearing. And that is all I have. Excuse me.
Great, thank you very much. Are there any questions for Ms. McGee, Ms. or Ms. Halsey at this time? Seeing none, any public comment?
I see none, Madam Chair.
Great, thank you very much. With that, we will now, the commission will now close executive session, and Ms. Palchuk sent you the link. It should be in your calendar at 12:30. Pursuant to Government Code Section 11126E, to confer with and receive advice from legal counsel for consideration and action as necessary, appropriate upon the pending litigation listed on the published notice and agenda, and also to confer with and receive advice from legal counsel regarding potential litigation. The commission will also confer on personnel matters pursuant to Government Code Section 11126A1. And the committee will reconvene in open session in approximately 15 minutes. So with that, we will now adjourn into closed session. If anyone has any questions, feel free to email me. But again, it should be on your calendars for today at 12:30, the closed session link.
Thank you and see you shortly.
Spencer, we might have a mutiny. You might have to take over.
I'm ready.
Did Gail get bumped off?
She's connecting.
Hi, everyone. I'm so sorry for my internet issues here today. Thank you so much for waiting. The commission met in closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. And we also conferred on personnel matters pursuant to Government Code Section 11126A1. And if there's no further business, any public comment, any further questions from the board? Seeing none, I will entertain a motion to adjourn, please.
So moved.
Thank you, Ms. Nash.
Second.
Thank you, Mr. Morgan. It's been moved and seconded. Ms. Halsey, if you'll please call the roll to adjourn.
Mr. Adams,
Aye.
Ms. Miller,
Aye.
Mr. Morgan,
Aye.
Ms. Nash,
Aye.
Ms. Paquin,
Aye.
Mr. Walker.
Aye.
Great. We are adjourned. I really appreciate everyone's time today. Thank you very, very much and have a great weekend. Take
Bye.
care.
Bye.
Series that's